and people will continue to join the webinar. And in the meantime, what I suggest is what I normally do, which is people pose questions in the chat, because that's kind of the sort of less chaotic method of getting the format of the questions and answers, as opposed to some kind of free-for-all where there's multiple people talking over each other. So that's sort of the ideal. So I'll try to keep the chat box open, and then whoever's here in the moment, I guess we have a couple of people, then we can go through the questions. I may rephrase the question depending on what's being posed, or I may make assumptions about the question. And if I'm wrong, you can always add more details in the chat, because we want to give the opportunity to provide some kind of response, but at the same time, because of the amount of context that may be needed from question to question, I may have to ask you to give more details. In that situation, then please feel free to pose a chat about this. I don't see anything in the meantime, but one thing that is standing out is that if you are in Canada, you might have come across in the media more of a discussion of immigration, typically in the context of the milestone.
Put the call to the customer service department.
Yeah. Well, let me just make a little adjustment here, right? I think I have to give the setting, so I have to mute all of you, essentially, unless it may be, for example, beyond their control. So it's analogous to, perhaps, I mean, based on what little we know, it is analogous to the TR to PR pathway, which was deployed in February 2021, where you had to have valid status and certain type of work experience, or not even work experience. In some instances, it was just being in Canada. I don't know if the increased amount of population and the concomitant housing crisis, which arguably in a small way is affected by international students. I'm not a geographer or urban planner, but from other experts who do have specialized knowledge, they say that the housing, which affects all Canadians, is not really necessarily affected by the proliferation of international students. And the reason that's relevant is because if they do deploy some temporary TR to PR pathway, they still want to address whether or not this is going to have an additional problem for the cost of housing for all Canadians. So the other factor that is of relevance is that there would be an election at some point, and because the time is running out for this current government. And although they've announced in December 2023 a potential program of some sort, arguably they would want to make sure that it is phrased or deployed in such a way so that it could not be seen by opposing parties as putting a priority of international students, for example, over and above the existing Canadian permanent residents and citizens. So those are some of the factors that may shape the scope and breadth of that potential TR to PR pathway. So my opinion thus far is that it would not be as broad as it was before, where you simply had to have valid status as a student, for example, which was very, very broad in terms of the categorization. So I think with that out of the way, I see the other question here, which is the humanitarian and compassionate applications and the possible challenges and success rate overall in the case of a loss of status inside of Canada. So in other words, the impact of a change in status to no longer having status for presumably inside of Canada agency. The majority of HNC applications are done inside of Canada. In certain narrow scopes, they could be done outside, just in terms of background to the general concept of HNC. And further context, rather, would be related to what is the mandate of an HNC application. So before the change in the law in 2015, there was a case in 2015 called Count the Sami, which emphasized that the phrase unusual and undeserved and disproportionate hardship should not be the standard by which child applicants for humanitarian cases should be granted permanent residency, primarily because children, from the vast majority of situations, do not deserve unusual, undeserved, and disproportionate hardship. With that being said, however, those phrases, which are still in the policy manuals, they still have some kind of effect when you are an adult applicant. And the concern is that the immigration officer at least ostensibly wants some context for what the person's status is, when was it maintained, when was it lost. So for example, if the person did come as a worker and got laid off, and maybe they did not have anything in their home country, and maybe there was some extenuating circumstance which caused them to remain here, maybe even working illegally. In that situation, the officer would, on the one hand, weigh the breaking of the law, i.e. working illegally, versus whatever the reason that the candidate had in their mind for working illegally. Was there an extraordinary reason, such as dealing with an ill relative in the home country and needing surgery, which costs money, or things of that nature? This is like an extreme example. And in the mind of the officer, that could mitigate the failure to maintain proper status and/or the failure to work without a proper permit, as long as the other primary preoccupation that officers have is also addressed, namely economic establishment. And so you may wonder, what is economic establishment? At its very minimum, the concept is to merely be not a burden on the government. So not in a situation where you have to take social assistance. But in that case, this is sort of a normative situation where if you don't fit any of the other programs for immigration, such as the family class, which relates to merely having a relation that can sponsor you, such as a spouse or working age child, then there's no kind of issue with economic establishment. But in contrast, all of the other economic-based programs, expressentry is sort of the umbrella, not to mention the business categories. If you don't fit those either, then what's the point of a H&C case? Well, essentially, it's that there will be a situation where people are inside of Canada. They don't fit any of the programs, either a family class or the economic categories, but nevertheless, something about their circumstances and, if applicable, the situation in their country of citizenship, combined with, for example, some degree of suitable economic establishment, could move the officer to say that despite the fact that you do not meet any of the criteria for the standard programs, either family reunification or economic, that nevertheless you should still have permanent residency, despite not fitting the typical programs which are based on well-established criteria and are embedded in the law and are a lot less discretionary. So this is an elaborate way of saying officers have a duty to look at the reason for losing status on a case-by-case basis, looking at the global circumstances of the person seeking permanent residency on H and C grounds. So the other component is the success rate for humanitarian cases. So typically the Immigration Department does publish statistics, and they seem to hover between 45 and 60% from year to year. Sometimes that's related to the government in power, where there is it seems to be an association with the more conservative party being a lot more rigid about the use of discretion to allow a person to come despite not meeting the typical criteria for the various programs of immigration. So the concern is that, again, because H and Cs are case by case, when you look at the aggregate, every case is so unique that you end up not really getting a significant insight just by the mere numbers, except maybe just this association with more conservative governments tending the agency success approval rate to go down, seemingly, at least in the past, when there was a more conservative government prior to 2015, right? So that covers sort of the scope of the questions thus far. There's no questions in the meantime, but because I have a YouTube channel and this ends up going on the YouTube channel, then in the meantime, on the assumption that other people may join the chat, which sometimes happens, there's always the sort of general types of questions that come up, and they vary from time to time, and I always like to go through those because people keep asking them, so by their nature, they are frequently asked questions. So one particular question is, can I get this visa, or which program should I apply for? And in some cases, even now, I mean, despite the fact that there is widely available immigration information directly from the immigration website, people sometimes have that sort of curt, brusque question. And as you could probably infer, it's impossible to say which program without knowing anything about the candidate. On the other extreme, there's a situation where people will, sometimes by texting or sometimes by emailing, they will have an elaborate 450-word background document setting out their circumstances. And then if they're even more diligent, they will set out the tentative programs or sub-programs under expressentry that they think they might want to or be able to qualify under. And as you may know, lawyers are selling their time. So like we don't manufacture clothing or fix things. We're just selling you our time because immigration law is highly specialized. And so even to review that 450 word narrative and the two tentative programs that might have been highlighted in that query, even then, because we're liable for advice we give, we would want to corroborate and get even more detail before recommending one program over the other. Because, for example, sometimes programs change or they get terminated or things of that nature. And if we advise to do one program, whereas another program is time sensitive, or let's say the other program has merit, but due to some peculiarity, which you have not put in your 450-word summary, we didn't see that. We can't simply say, yep, go with plan A as opposed to plan B. So that's an elaborate way of saying most lawyers charge a consultation fee. And the people who don't, then you may want to think of it as analogous to, the various online services provided by Google, Facebook, etc. Namely, if it's free, then you may very well be the product, right? So that's analogous to saying you're not getting advice when you're asking something and it's not free. You may be just simply getting steered into a certain pathway, and with the assumption that perhaps with a degree of encouragement without sufficient context, or perhaps dealing with desperation, which does happen in the immigration setting, you simply hire a lawyer or a licensed immigration consultant, and they, if they're not ethical, then they would simply tell you to do this program without proper vetting to make sure that the fundamentals are there and that if there's actually merit to filing an application under a certain category. So that's sort of the broad, long-winded answer to one of the frequently asked questions, which is there a free consultation? So that one is worth mentioning because there are permutations from time to time about this. And on the other hand, people say you should think about other people and do something. So this is why I have webinars. So people who are financially unable to pay for a consultation do have this opportunity to pose a question where at least there's some guidance in a general sense. And thereafter, they at least have some direction and maybe some intuition about whether or not what they want to pursue is suitable in some capacity, because the immigration department does, arguably, their preference is that you self-file. No matter what degree of complicated circumstances there are to your potential case, the immigration department encourages you to self-file, and they don't really care about the result. They just want to make it easy for them. And if they get what's called a cost recovery fee or filing fee on the process, well, that's an added bonus for them. So that means people are left with looking for alternatives in terms of finding out information whenever there is an ambiguous type of instruction or a confusing type of form contained on the Immigration Canada website. And this leads to things like the crowdsourcing types of information gathering, such as through online fora and things of that nature, right? So I think I heard something. I heard a hand being raised, and it's not in the form of a text question, but feel free to pose a question in the chat at least, right? Let me just
Sure.
see.
Yeah, I'm sorry for that.
Oh.
I'm raising down my hand. Thank you.
No problem, yeah. Because this will it's being recorded, so this will be on the YouTube channel, right? So, but there is one question related to visitor record-based super visa extension. Okay, for more than one time. Okay, so then this question relates to extending temporary status in Canada. And the idea is that temporary status is, by its very nature, temporary. So there are anecdotes that people have extended their status 3 times, sometimes 4 times, sometimes 4 or 5 times, particularly during the time of COVID, where it was simply not possible to leave. So that was an extenuating circumstance. But when thinking about what the mindset of the officer is when dealing with visitor record extension in Canada, which is basically saying, please let me stay another 6 months, officers are bound to consider certain fundamentals, such as the amount of funds you have for the duration of the 6-month extension and the purpose for being in Canada, particularly whether the purpose is a temporary one. Because if it is temporary and you have the funds to reside here, then at least on its face, the officer should be satisfied and grant a visitor record extension. But with the passage of time, it may become more difficult to have a new purpose for being in Canada for an additional 6 months. It's not impossible because everybody's circumstances in life are different. You may have the funds to continue visiting more and more different places in Canada and do what a tourist does, particularly a more well-off tourist. And in that situation, because Canada is the second largest country in the world, you could say, well, I have the money and I'm interested in skiing in British Columbia and, visiting Saskatchewan to see what an incredibly flat place Saskatchewan is, or things of that nature. Or the Anne of Green Gables house in Newfoundland, which is apparently a big draw for a lot of Japanese tourists. And those are all extremely far away from each other. So that's sort of the kernel to the idea that you should have a temporary purpose to be in Canada, because that's what a visitor does. They come for a temporary purpose, and it's not to work in 99% of cases, unless you're a religious minister, who I think that's the only person or category of persons I can think of who are allowed to work while on a visitor visa. Just so you don't get misled, I'm not saying something analogous to what people do, which is volunteer in church. That might be okay, but simply volunteering for a private company is work, or akin to work, because you are depriving a Canadian of that ability to volunteer or take some kind of unpaid internship at a place of employment. So I just wanted to get that squared away, right? So with that in mind, I'll take a look at the additional question, which is, I think, as follows, right? Oh, actually, before I deal with that, there was sort of a visitor record follow-up question. So that relates to, what if there's a visitor record request during an application for permanent residency under the humanitarian and compassionate category? So for this, the law does address this. I believe it's regulation 20 or 22 of the Immigration Refugee Protection Regulations. I don't remember the number exactly. And that does have the accommodation for a person that could have what is called dual intent. And that could be to maintain temporary status as long as the officer is satisfied that the person will leave if their temporary status is not granted. And then at the same time, you could have a permanent resident application in process. So there's a regulatory basis for an officer to grant an extension in that situation. With that disposed of, there's a medical admissibility question, where the person is indicating that there's a certain degree of colitis as part of a diagnosis, and the goal is to file for permanent residency in Canada. And it says there's an assertion that this does come under, this may be one of the conditions that falls within the finding of medical inadmissibility. So the question is how to overcome this potential medical inadmissibility. So there is the reference manual that Canadian designated medical practitioners or panel physicians have. And that relates to categorizing the amount of treatment needed for most medical conditions that people have, most somewhat serious ones. And in some cases, I don't know ulcerative colitis off the top of my head, but I know for example, cancer, it depends on how long you've lived in remission with cancer. So if it's been more than 5 years, then the medical inadmissibility will not be a finding, but if it's been less than 5 years, it might be. And if you're familiar with that manual, M5 is the code for inadmissibility, and M3, which is M as in Mary 3, which is in the middle, which means you might be inadmissible, but this could be revisited. But the overall scope of how to address this is mandated in the law. So if you do file for permanent residency under typically the economic categories, because there's no exemptions, but if you file for PR and you meet the requirements for the points, let's talk about, for example, expressentry, then they conduct the admissibility assessment, and then that's triggered by the receipt of a panel physician report by the medical officers, typically in Ottawa or Hull, Quebec. And the medical consists of data, blood, samples, and resultant numbers and things of that nature. And there could be an allegation that you have a condition, the degree and seriousness of which may cause medical inadmissibility. And then there is the requirement for what is called a procedural fairness letter to be sent out. And they give you 60 days, usually, to respond to that allegation. And the allegation would be in writing. It would say a panel physician has determined you have ulcerative colitis of a severe form, and that the cost of treatment, taking into account doctor's visits and perhaps in-hospital care, would constitute an excessive demand on health services. Keep in mind the context for what constitutes an excessive demand is a dollar threshold. I believe it's around $22,500 as of 2024. So the procedural fairness letter is essentially saying that the amount of care you would need with a medical condition of the one you have described would exceed the average Canadians by 22,000, which is the threshold of inadmissibility. So what do you do? Well, as part of the response, you could tackle it two different ways, or both of the two different ways. One is to say that, no, I've got a specialist physician, and he says the amount of intervention and treatment that would be needed within the next 5 years would be quite minimal. That's directly attacking the finding with credible medical evidence, presumably, or preferably rather, by a specialized physician who could, in a sense, trump the general medical practitioner that is deployed by the Canadian authorities. And they would not really have anything to say if you have a specialist saying that the nature and the degree of the condition is not as expensive as portrayed in the procedural fairness letter. On the other hand, if you can't medically disagree with the allegation, then you could try to say that, okay, but I have money. I have acres of land which I'm going to dispose of. Here's the property land valuation. And Canada is going to be my home, so I do have some ability to take care of this medical condition. And that would be an alternative method to deal with this. But really, to avoid confusion, it's better to, before even considering permanent residency, it's better simply to get an evaluation by an immigration lawyer. We've done these for people in the past as well. Sometimes we ask the person to get a medical report, and then we do the research as seen by the lens of the Canadian immigration authorities. So that would be sort of the strategies to deal with medical inadmissibility. And excuse me 1 second. Oh, there's a related question again. So how much money should I show them? So I hate to be trite and blunt and brusque, but really it's as much as possible. If we think of the minimum amount, then the context again is important. So it depends on what would be the dollar figure that is usually mentioned in the PFL. They would say that this exceeds 22,000 per year, and in fact would cost 40,000. That would give you a gauge, because most of the procedural fairness letters I see, they do the dollar value count. So that would be sort of the way to go, aside from just as much money as possible. So with that out of the way, there's looks like a economic-based immigration question, which is, let me see, if my job duties and responsibilities don't match with those qualified for an eligible occupation under a PR program based on the NOC code, does that make me eligible if I can submit an experience letter from an employer stating my roles and responsibilities, which will actually match those required? Or will it be invalid based on my job title, which falls under a different NOC code? That's a lot of question. And if I try to distill it, the question is, on the one hand, when you present your experience, you have really your work reference letter. The work reference letter is required to have your job title and your job duties and other things too, like your salary, maybe any increase in promotion or increase in salary. In some cases, there may be more specific reference to people you supervise or a change of responsibility. So those are sort of the hallmarks of a work reference letter, which goes into the express entry categories. So the question could be, what if there is a mismatch between the title and the duties? Then in that case, the fundamental thing to keep in mind is that although you may have a certain job title in the job reference letter, which would be supported, or which would be rather supporting your PR application, it would also have the job duties. So then when we look at how an officer would be reviewing this from the point of view of qualifying under, let's say, CEC or federal skilled worker or federal skilled trades, then what they're supposed to do is give more significance to the actual duties. Because sometimes employers, especially large institutional employers such as banks, they have idiosyncratic, prolix, incomprehensible job titles. And then it's up to us, the lawyer, oftentimes, to look at the complex job reference letter, which for some unfathomable reason, HR does not want to alter. So they don't give a letter that completely comports with immigration criteria. And it's up to us to make the case that despite the weird job title, the duties, as stated in a very highly technical or specialized or idiosyncratic way, do match an appropriate NOC level, tier 3 job or higher. So that's sort of the way to deal with the ostensible or potential mismatch rather between the job reference letter's job title versus the duties performed. The duties performed should be the basis to advocate for meeting the appropriate NOC level occupation, and then that's your foundation for PR. So I hope that is the suitable context to the that sort of economic-based category. Don't see any other questions, but again, I still have time.
Sorry, just working on it now.
Okay. Okay. So with that in mind, okay, that relates to a question. It looks like, is age a factor in determining if someone is able to apply for citizenship? Now, I'm presuming it's citizenship as opposed to permanent resident status. If not, just clarify in the chat, right? But for the moment, if we look at the question of the impact of age on citizenship, then we just back up a little bit and look at the basic requirements of citizenship. Primarily, the main one is 3 years of physical presence out of 5 years, and then the other one is suitable evidence of language facility in one of Canada's official languages, and no inadmissibility, such as being under a removal order or being under a sentence of imprisonment or some other kind of criminal inadmissibility, and not being a fugitive from justice in another country. So if we take those, then the only one that is directly affected by age is the language requirement, because you have to meet the language requirement and have a normative or average, I believe, amount of language facility, unless you're over the age of, I believe, 55. And in that case, they waive the language requirement, and then you don't need that, and you can become a citizen. So in the very narrow circumstance, the impact of age does have an effect on the qualification for Canadian citizenship. So with that in mind, don't see any other questions, but again, I still have time. So one of the other somewhat common issues, particularly for people who have a history of numerous applications in Canada, is when some information was omitted on an application in the past, and now they want to try to correct the record now, despite the fact that they've omitted information about some perhaps material aspect to their application. This situation does come up oftentimes with people who, for example, they may have filed for a visitor visa to Canada, then come and visited, and thereafter they may have changed that to a study permit, which is application number 2, and then they may have extended their work permit after graduating, so that's the 3rd application, and then they may contemplate permanent residency. So in that situation, they realized, or maybe they knew the entire time, that they did not declare, for example, being detained in the United States, or they did not, for example, declare work experience in their home country on their study permit application. And then, so what do you do? Well, the short answer is, with context, you do declare the potential misrepresentation, but at the same time, you don't declare it blindly, you declare it with some context. Context would be to show whether or not it was material to the application, where the falsehood took place at the time. It's a very technical legal question, because that touches upon the concept of materiality, namely whether the misrepresentation was material to the officer's assessment when granting you the previous visa application. So it's very complex, and I'm a little bit disconcerted when I see people try to tackle that themselves, because I do have people consulting me about this, and I reiterate that it's good to get a lawyer's filing with case law on top of a response to that. Just because the case law does change from time to time, and the concept of materiality and the material misrepresentation may evolve, and sometimes in your favor, and you want to avail yourself of any positive changes in the law. So that's just something to keep in mind in terms of a somewhat common situation where there's some inaccuracy in the past which you want to rectify in the future, especially when permanent residency or citizenship is on the line. So I think another question related to citizenship is the challenges for those applying for citizenship. this type of application for citizenship, there's, broadly speaking, at least for the cases we see, there's two challenges. One is people who just don't meet the days. They don't have the 1,095 days within the 5-year period. And oftentimes that's due to employment outside of Canada. And they are reluctant to let go of that employment. But they want to get the citizenship because sometimes the Canadian citizenship can enhance their employment outside of Canada. So the consequence is that the law now, for the past, I believe, 6 years, has been very explicit that you simply must have the days of physical presence inside of Canada, with very rare exceptions, such as working for the armed forces of Canada, or a very narrow kind of discretionary pathway, which I've never seen successful. So that's one category of difficulties in getting Canadian citizenship. The other one relates to admissibility. So that means in your pre-citizenship history, such as what I mentioned before, maybe you did a visitor visa application, study permit, then work permit, and then you got PR. Sometimes they discover the misrepresentation during the course of assessing the citizenship, because when you fill out your citizenship application, there's another set of information, and then they have access to your Canadian immigration history, and they could say, wait a second, this person said they were residing in the United States on their citizenship, but that was never mentioned before. And then in some situations, what if you were granted permanent residency as a refugee or protected person, and your presence in the United States meant that you could have gotten refugee protection in the United States? Then that could lead to not only the denial of citizenship, but also the taking away of your permanent resident status because of an inconsistency, which was not detected and was material and led to the taking away of status. So that's one example of the sort of enforcement-based problems or challenges with getting Canadian citizenship. So that's sort of a more fundamental question is, what is the difference between permanent residency and citizenship? So with permanent residency, that in the vast majority of cases, unless you are an adopted child, it's something you have to go through first because that's the way the law is structured. So permanent residency is contingent upon complying with one of the programs for permanent residency, such as family class, namely spousal or sponsored parent or dependent child, or the economic categories, such as startup visa, provincial entrepreneur, expressentry / FSW, federal skilled worker, or expressentry / CEC, or Canada Experience class, or the federal skilled trades program. So that is the precondition for before getting citizenship, is to acquire permanent residency based on the criteria for one of those programs. And to my mind, the only exception, the only way you could become a citizen automatically is if you're born and at the time of your birth, one of your parents was Canadian, or the analogous situation is if you're being adopted by a Canadian parent, and then they're, depending on the adoption scenario that took place, you might be able to apply directly for Canadian citizenship and simply overreach and overarch and surpass the need to apply for permanent residency. So that's sort of the very basic fundamental difference when between those two categories. So with that in mind, we're no particular questions in the chat, so I always go to my go-to, which is the frequently asked questions for this. And one which particularly stands out is just because of the proliferation of various channels of information, such as online fora, and also the Canadian immigration website, and also people just talking in a community, a particular ethnic community. Sometimes there's just a rumor that comes out that says there's a program that is coming out, and oftentimes it's not the case, because every immigration lawyer is plugged into the announcements by immigration, and also we get the benefit of our lawyer colleagues meeting with the Department of Immigration and Citizenship periodically, and they give us, not always, but they do give us some clarity about things that are coming up in the short or medium term. Sometimes they just announce a program abruptly, such as the TR to PR one from February 2021. They just gave us no notice about that. But that's sort of the exception rather than the rule. And now, given the sort of political climate is changing, then it would be a bit odd if they don't kind of massage the public with public relations about any possible successor to TR to PR as a program, just to contextualize it, to assuage the concerns about the needs for the existing PR and citizen inhabitants of Canada as a whole. They want to address that first. So that's why it's, again, unless you've seen somebody say, this is my permanent resident visa, and this is how I got it, and the fine print on the confirmation of permanent residence, it would say the category number. It's a code. And that's how you would figure out if your friend actually got PR through an ordinary program or some fictional program, which really may not exist. So another question relates to sponsorship. The goal is to sponsor an aunt for permanent residency and down the road citizenship. So the question is sponsoring an aunt possible, or is it very difficult? The short answer is it's very difficult, but scratching the surface and giving context, the idea is that the person has to be a member of the family class to be sponsored. So that is typically a spouse or common law partner, dependent child under the age of 22, or a parent whose child is a Canadian citizen or permanent resident. So in terms of sponsoring an aunt, the closest thing that could happen is if you are the relative in Canada and you're completely alone, which means you don't have a wife or husband or partner, you don't have a child, then you could sponsor your aunt under the last remaining family member category. That would make the aunt a member of the family class, because you have absolutely nobody in Canada. So the colloquial name for that is the lonely Canadian category. And then you can bring one relative as long as you have nobody in Canada. So that'd be the only way. Aside from that, there's humanitarian and compassionate, but as I said earlier, those tend to be, in the majority of cases, applications where the person is already in Canada. And that's, as I said in an earlier response, it's a highly discretionary application. So it's not really advising to take that kind of application, even if the person is in Canada, unless there is a whole host of other factors that are being assessed, such as country conditions, where the aunt hails from, and its potential for economic establishment, etc. So with that being said, we have barely 3 minutes left. So I encourage you, anybody, to give a short, pithy question in the remaining time we have. But for the sake of content, I'm just going to go to another question, unless I see something. So yeah, another frequently asked question relates to this idea about studying in Canada, and whether or not, if there's a lapse in studies, can they restore studies, the student status? So there's some flexibility in the immigration system to forgive an absence of studies while possessing a student permit. But really, I believe it's after 6 months, if you have not studied without a valid explanation, then it's very difficult to justify renewing your study permit when it's time to renew it. Let's say you had a financial issue and you stopped studying because you couldn't pay the semester's tuition fees, so you didn't pay. In that situation, what you're supposed to do is change your status to visitor or leave Canada. Otherwise, if you're in Canada, we can try to fix it, but it becomes a much more discretionary application, such as a temporary resident permit, or TRP, combined with a study permit. And then we'd have to explain the reason for the lack of studies. But again, that's very discretionary. And we do those, but we prefer that people simply, when at all possible, take the less complex legal route, because everybody's life should be as simple as reasonably possible, unless there's no choice, right, for them. So down to the final minute. So I don't know if I can really insert another frequently asked question. I'll take another look at the chat. And yeah, I think for the most part, I don't really see any other question posed. So with that in mind, I hope this was useful. This will go up on YouTube. Thanks for reaching out, and enjoy the rest of your evening. Bye-bye.